In this video, we're going to be talking about the history of equity. And this is the very beginning of the equity and trust videos that I'm going to be doing. So it may start quite heavy and quickly because trust is that sort of topic, but I'm going to try to make it as simple as possible by giving you a good understanding of the backdrop behind equity, so that when we start getting to the substantive part of the actual videos themselves, you'll actually understand why equity exists in the first place. So, what is equity? Now, strictly speaking, the principles of equity are the rules which have been developed by the courts of Chancery over the centuries. And in the Earl of Oxford case, it was said that the cause why there is a Chancery is for that men's actions are so diverse and infinite that it is impossible to make any general law which may aptly meet with every particular act, not fail in some circumstances, and not fail in some circumstances. And in Dudley and Dudley, it was said that equity is no part of the law, but a moral virtue, which qualifies moderates and reforms the rigour, hardness, and edges of the law, and as a universal truth, it does also assist the law where it is defective or weak. So equity is the means by which a system of law balances out the need for certainty in rulemaking with the need to achieve fair results in individual circumstances. So equity is mitigating the rigours of the common law. The English concept of equity is built on the idea of conscience, in that the courts consider the conscience of the individual defendant in any particular case. It's all about delivering fairness and sort of mitigating the circumstances where the law itself hasn't quite worked out. So the origins of equity. Now, equity draws on the principles of fairness, justice, morality, and ethics. And underlying all of these principles is the principle of conscionability. It is said to moderate the harshness of the common law. So these were the foundational principles of equity. Everything in equity is underpinned by conscionability. The idea is that a sort of sclerosis of the common law had set in, as a result of which it failed to adapt to new developments in society and economy, and the Chancery provided remedies for these particular problems. And equity is founded on these principles, but like the law, it depends on precedent. It is necessary to understand its development to appreciate how equity works. So, like how the law works, it is based on precedent and it is not discretionary. So historically, there remained a right to petition the king directly if it was thought that the decision of the common law court was unfair or unjust. So, for example, a tenant of land who was unjustly dealt with in the court of his local lord could seek a remedy directly from the king if he was unsatisfied with the decision of the court. However, the proliferation of suits that were brought directly before the king eventually required the creation of a separate mechanism for hearing them. As a result, the position of the Lord Chancellor, among other things, was created in the medieval times to hear those petitions which would otherwise have been taken directly to the monarch. The Lord Chancellor is an ancient office of state dating back, in some accounts, to pre-Norman times. The Lord Chancellor could be considered to be the king's senior minister and advisor. During the 13th century, he was delegated to consider petitions addressed to the king. So these petitions would pray that the person we now call the defendant should be brought before the Chancery to be examined and dealt with appropriately, and his presence was enforced by a writ of subpoena. That is an order that he should appear before the Chancery on pain of forfeiting a sum of money. And the Chancellor was the keeper of the king's conscience. So his job was that if the king was doing something unconscionable, the Lord Chancellor would effectively have a word with him. So, in other words, the defendant would not be permitting to enforce a common law right or rely upon a lack of common law formality if to do so would be unconscionable. So originally, the Chancellor did not have any clearly defined jurisdiction, but dispensed an extraordinary justice remedying the defects of the common law on the grounds of conscience and natural justice, a function for which he was well qualified, and he was commonly ecclesiastic, well versed in both civil and canon law. And the Chancellor was able to give relief by the exercise of the King's authority. He was empowered to issue royal writs on behalf of the King through the use of the Great Seal. Later, the Lord Chancellor started to hear cases in person, a tradition that remained until the end of the 20th century. So the Lord Chancellor was the keeper of the Great Seal, and this seal gave the Lord Chancellor royal authority, which was a lot of power, to act on behalf of the King. One common form of relief was an injunction, which was introduced in the 16th century, granted by the Court of Chancery against the unconscionable enforcement of a common law judgment, with the threat of imprisonment for breach of the injunction itself. This inevitably produced a rivalry between the Chancery and the common law courts. And there's this quote, which is attributed to John Selden, which says that equity is a roguish thing. For law we have a measure. Equity is according to the conscience of him that is Chancellor, and as that is longer or narrower, so is equity. 'Tis all one as if they should make the standard for the measure a Chancellor's foot. So historically, equity was discretionary, and the Lord Chancellor would simply do what he thought it was right. In the absence of fixed principles, the decisions made depended to a large degree on the Lord Chancellor's own ideas of right and wrong. However, it was a frequent criticism of the Chancery in the 16th and 17th century that the Lord Chancellor's discretion to dispense justice ad hoc on the ground of conscience produced justice that varied markedly in quality from one Lord Chancellor to the next. So Selden is joking here that the official measure of justice might as well be the foot, because it varies according to the length of the Chancellor's foot. This meant that one Lord Chancellor could come up with one ruling on a set of facts, but another Lord Chancellor at a later date on the same facts could come to a completely different conclusion. And, discretionary authority is incompatible with the rule of law, but this was a long time ago, and things have since, improved, and equity is now based on precedent. So it is now generally accepted that equity's naked power of improvisation has long been spent. One judge has even asserted that in the field of equity, the Chancellor's foot has been measured or is capable of measurement, although his Lordship Judge Bagnall, added the following caveat: this does not mean that equity is past childbearing, simply that its progeny must be legitimate, by precedent out of principle. So we can see that equity has improved, but there may be some areas where there is still room for improvement. But that was a general historical development. So let's continue with this discussion now, with the competition between equity and common law and how that has progressed over the years. Now, in the 16th century, the Court of Chancery developed the injunction to enforce its rulings. This was opposed by the common law courts, which saw it as interfering in its jurisdiction. So there was a tension between the common law and equity. The Lord Chancellor believed that injunctions were necessary to set aside a judgment, even if it were technically good, where it has been obtained by oppression, wrong, and a bad conscience. By a common injunction, he would restrain parties to an action at common law, either from proceeding with their action at law or having obtained judgment from enforcing it. The validity or invalidity of these injunctions would, it was recognised, determine the question whether legal supremacy was vested in the common law courts or the Chancery. Now, the case law has also shown this sort of tension as well, and we see here in Heath and Ridley in 1614, the common law courts are seen complaining about equity, stating that if any court of equity doth intermeddle with any matters properly triable at the common law, or which concern freehold, they are to be prohibited. So you can see how even the courts were voicing their opinion about the conflict between the common law and equity. Now, James I commissioned Francis Bacon to report on the practice and jurisdiction of the Court of Chancery. He made a decree that the court should continue to provide relief. So the matter on whether legal supremacy was vested in the common law courts or the Chancery was referred by the king to Bacon, who was the Attorney General. And Francis Bacon fell down in favour of equity in his judgment. So he said that the Lord Chancellor should continue giving relief. So he concluded that the injunctions were valid and in 1616 accordingly issued an order in favour of the Chancery. This did not, however, completely resolve the matter. In the period following the Glorious Revolution, in which the sovereignty of Parliament was established, some parliamentarians regarded the Court of Equity as exercising the personal prerogative of the Crown as a link to the pre-Civil War doctrine of divine right. In other words, the status of Parliament could be seen following the Glorious Revolution, where parliamentary sovereignty was established. Parliamentary sovereignty meant that the king could only continue to exercise its authority through the will of Parliament. Considering that the Court of Chancery was a royal court, exercising royal authority in a time where parliamentary sovereignty existed, it was really a surprise that that court actually survived. But the Court of Equity did survive, and probably because it was doing a good job. And in 1690, a bill was placed before Parliament to prevent the Court of Chancery from overturning judgments made in a common law court. The bill did not pass, and from that date there were no further challenges to its jurisdiction. And equity developed from being a discretionary jurisdiction to one with established rules based, like the common law, on precedent during the 18th and 19th centuries. So equity adopted the common law rules on precedent. So you had to show a case that supported your arguments as you did in the common law. And if you couldn't find a case or statute, there isn't really much mileage. The court doesn't judge on really what is fair or moral. Their decisions are based on precedent. So as the principles of equity became more fixed, the discretionary jurisdiction of equity began to fade. And Lord Denning has even stated extrajudicially that the courts of Chancery are no longer courts of equity. They are fixed and immutable as the court of law ever were. As the number of cases proliferated, the court developed. Cases were heard by the Lord Chancellor, the Master of the Rolls, and by the Lords Commissioners. In 1813, the first Vice-Chancellor was appointed. The Lord Chancellor could and did sit as a judge at first instance until the Supreme Court of Judicature Act 1873. So since this time, the rules of equity, and in particular the rules relating to the laws of trust, have become far more rigid. So the fusion of the two jurisdictions. Although equity and common law were separate jurisdictions, they were influential upon each other, and there were attempts to resolve the differences. Some equitable principles were followed in the common law courts. So the common law courts, for example, began to apply equitable rules and recognise trusts. But note, prior to the Judicature Acts, equity was enforced exclusively in the courts of Chancery and not at all in the courts of the common law, so the Common Pleas, Exchequer and King's Bench. Although in origin the jurisdiction of the Court of Chancery was undoubtedly based on moral principles designed to remove injustices incapable of being dealt with in the common law courts, equity was always, at least until the Judicature Acts, essentially a supplementary jurisdiction, an appendix or gloss on the common law. So to some extent it is still just an appendix, but recent developments would make this statement a bit of a misleading one. And in Winch and Keeley, it demonstrates the law's increasing recognition of the trust and willingness to enforce and uphold trusts. However, by 1873, two main problems were seen to exist. The Chancery courts were slow, and they would, where appropriate, refuse jurisdiction, requiring the plaintiff, the claimant, to resubmit his case to a common law court. So what happened was that many cases went through the Chancery courts, but ultimately the parties were told the matter was not equitable and thus had to be resubmitted in the common law courts instead. And this made the courts very slow and a bit backlogged too. And if you ever read Bleak House by Charles Dickens, this very situation is satirized in that case, in that book. So give it a read, but it may be a bit bleak if I'm honest as well. But anyway, the 3 Acts of Parliament were passed over 20 years, which culminated in the Supreme Court of Judicature Acts. There was the Common Law Procedure Act 1854, which gave the Common Law Courts ability to give equitable remedies. There was the Chancery Amendment Act 1858, which gave the Chancery Courts power to award damages, which were previously only available at the common law. So the parliamentary acts here allow the 2 courts to give the same remedies. And then there was the Supreme Court of Judicature Acts 1873 and 1875, which placed the Court of Chancery within the same court, the Supreme Court, but with its own division, where it now remains. So the Supreme Court of Judicature Acts 1873 and 1875, placed them within their own separate divisions. This is key. So historically, we had 2 separate streams of jurisprudence emerging in English law, the common law as one side and equity on the other. The Judicature Acts abolished most former courts. They were all amalgamated into the Supreme Court of Judicature, which is not the same as the Supreme Court we have today. That was created in 2009. And this administered both the law and the equity. And they are now known as the Senior Court. Even though there is no longer a physical separation of these 2 codes and these 2 principles, the intellectual separation of the principles still do remain. And generally in all matters not hereinbefore particularly mentioned in which there is any conflict or variance between the rules of equity and the rules of common law with reference to the same matter, the rules of equity shall prevail. And that's from section 25, subsection 11 of the Supreme Court of Judicature Acts of 1873. So section 25 of the Supreme Court of Judicature Act states that where there is a conflict of the common law and equity, equity shall prevail. So that really wraps up our understanding of the history and the background of equity. And in the next video, I will just build on this a little bit further to give you a little bit more of the context about the current approaches to equity and this understanding of conscionability before we move on to talk a little bit about the equitable maxims that exist and get into the substantive aspects of my video series on equity and trusts. Now, if you have any questions about equity and trusts and the background and the historical context of equity and trusts, then please leave a comment below and I'll get straight back to you. But if not, don't worry, just subscribe to my channel and I will make sure there's another video in the next couple of days. Thank you very much for watching.